A windfall, maybe from that rich great uncle that you never knew. But what if you opened up your mail tomorrow to find out you're the heir to an estate of an undisclosed amount of money, but to get it, you have to sign away 25% of it. That's what one local woman says actually happened to her, and now she's getting sued. Our Leah Linscheid has tonight's call for action.
This is a story about a man most of us never got to know.
No, I never met him.
Not even his own family.
He's my mom's cousin.
This is Vicky Feger. She's a distant cousin of Thomas Berry, a man who spent his life as a state capitol locksmith. By all accounts, a fair and honest man, living on modest means.
It talks about in his obituary how he followed the rules so clearly that one time it says Tom followed the stringent key card process so strictly that he once would not issue a key to a state VIP because they did not follow proper protocol.
When Berry died unexpectedly last spring, there was no one to call. No brothers or sisters, no wife or kids.
I'm going to cry because that's what makes me so sad about it.
And that's where the story of this honest, frugal man takes a strange turn. When Vicky received a letter stating she was eligible as a distant cousin to inherit part of his estate.
And we all got FedEx packages in the mail.
A company called Skoll and Remica was offering to prove Vicky and her siblings were heirs to Mr. Berry's estate for a fee of 25%.
And that says the amounts we recover are often small, sometimes only a few $1,000s. I mean, what she doesn't say could also be millions of dollars, you know what I mean?
Vicky ultimately signed the contract. Then shortly afterward, she was contacted by the guardian ad litem assigned to the estate, who informed her that frugal Mr. Berry had amassed a fortune worth $3.4 million.
Oh my God, it's worth a lot more money than I thought, and I just gave away 25% of it.
That is when Vicky started asking more questions.
And then I started doing more Google searching and researching, and I was like, oh my gosh, this is not good. Like, this isn't right. It's such an obscure industry that nobody sort of knows what to do with this.
It was hard for us to find anyone who knew much about heir finding. The state has a law about heir finders, but it only applies to unclaimed property or property that's already gone to probate court.
Most often it arises as ethical problems.
We ended up in Pennsylvania talking to forensic genealogist Michael Ramage. He outlined some of the same concerns Vicky had with the practice, starting with the fact that heir finders often don't disclose much information about the estate they're pursuing.
Because they don't want them to find out on their own what estate it is, so that they don't have to sign the contingency agreement.
A statement from Skoll and Remica says the company talked to Vicky in an open and fair manner, sharing all the information they had at the time they contacted her, including the name of the estate. The company says it had no information about the value and didn't learn it was a large estate until almost 7 months later. There are other concerns with the industry. Ramage says these companies hire runners who keep tabs on estate court so they can get to heirs weeks before the court has an opportunity to contact them, often at a cheaper price. In the case of Mr. Berry's estate, the guardian ad litem in the case had petitioned the courts for $5 grand to pay an heir finding company. Compare that to the $700,000 Skoll and Remica might have made on 25% of Berry's $3.4 million estate. So what if you get one of these letters? Michael Ramage has one major piece of advice. Contact an attorney.
Those lawyers should be able to tell them whether or not the arrangement with an heir finder is legal, or is asking for too much money or too large a share of the estate, or whether or not it might be easy just to find the relative by perhaps contacting a forensic genealogist.
Okay. This is their 25-page injunction against me and restraining order.
Vicky did more than that. She filed complaints with the Better Business Bureau and DACCAP. She now says Skoll and Remica is suing her for defamation.
That's the cease and desist. I mean, he was this honest man.
Vicky says she's being honest about her situation. Maybe a nod to the legacy of her distant cousin.
I'm just going to advocate for people, and I want people to be informed. I don't want people to have FedEx packages show up on their doorstep and go, oh my God, I have to sign with these people. You don't.
Skoll and Remica also commented on its lawsuit against Vicky Feger, saying it drafted a cease and desist letter long before she filed a complaint with the BBB and DACCAP, after the company says she was making false statements to its other clients. Skoll and Remica also had this to say in its statement: "We have been in business for 70 years with thousands of satisfied clients and no prior complaints. You asked us to speak for our industry as a whole, but we can only tell you about our practices as honest and ethical." The company also points to its A+ rating with the Better Business Bureau. With tonight's Call for Action report, I'm Leah Linscheid.
Leah, thank you. If you have a call for action for our volunteers, you can call them every Monday, Wednesday, and Friday, 11 a.m. until 1 p.m. at the number there on your screen, or you can call for action anytime at channel3000.com. Well, hopefully, more